So we'll do this as a discussion, a kind of question and answer rather than just a straight presentation from Cathy. And then we'll have question and answer for hopefully 20 minutes at the end. I'm going to save the most controversial question for last. But the reason that I wanted to run this webinar this evening is because I attended a brilliant conference organised by Professor Cathleen Kaveny, who is our guest this evening, who has a joint appointment in the Schools of Law and Theology at Boston College. She organised an excellent conference about a month ago, I think it was now, on the rule of law. And I felt that it really would be worth bringing some of that conversation to those of you who were not able to be in the room with us, particularly to a UK audience, but I can see that we have some US audience with us as well this afternoon, this evening. So Cathy, I want to open by saying, can you tell us what led you to think that now was a moment when a conversation on the rule of law amongst Catholic and Catholic adjacent scholars seemed especially needed?
Oh, well, thank you for the question. But first, I would like to thank you, Anna, for inviting me to participate in this Zoom event with you and your wonderful center that bridges practitioners and theoreticians, because I think that's really the heart of our work. But also thank you for your wonderful presentation at the Rule of Law Conference and really digging into the Catholic encyclical tradition to find ways to, to bridge the conversation between, scholars, secular scholars of the rule of law and scholars of Catholic social teaching. And that was really the point of the conference in a way to say, look, we've got all sorts of issues about people who are in a situation of vulnerability, not because they are disobeying the law, but because the people responsible for the law aren't acting in a way that's transparent, that's clear, that's fair, that's respectful. And I was thinking in particular about some of the events, the terrible events that have happened in the United States around ICE, as well as the US's reaction to certain norms of international law. So I thought we need to have an interdisciplinary conversation where we can bring together secular lawyers who think about the requirements of the rule of law together with experts in Catholic social thought who think about the requirements of the common good. And that was really the name of the conference, the rule of law and the common good. And part of what I wanted to get people to think about was the relationship of substance. What does it mean for a community to flourish? What does it mean for a community to protect rights? And procedure, which is, what we normally think of when we think of the rule of law. Due process is one term, at least in the United States, that's used a lot about the rule of law. And part of where I thought the conversation could go and where I'm hoping it continues to go is a recognition that you need both substance and procedure for human flourishing and for the common good. And the legal community has said a lot about procedure, but not a lot about substantive flourishing. And the Catholic community, while it talks about law and it talks about the requirements of the government, talks more about flourishing in terms of rights and the common good as the good of the individual and the good of the community, but hasn't gotten as much as we might need to now into the weeds of how certain kind of procedures can facilitate that. So that's what the conference is or was, and what it will be. It looks like, this is an advertisement, the proceedings will be jointly published by the Journal of Moral Theology, which is an American journal of Catholic moral theology, and the Journal of Law and Religion, which is also published in the United States. And it is a journal that really integrates scholars of religion and scholars of law in a common conversation.
Good plug at the end. Very smoothly
Yeah,
done.
yeah, buy the journal.
So one of the things that was really interesting to me about the conference was there wasn't a singular Catholic voice or Catholic perspective, because there were those who, even within the Catholic tradition and as Catholic philosophers, fell more on the procedural side than the substantive side, those who fell more on the substantive side, but with also lots of things to say about procedure. So could you take us back to the beginning a little bit for our next question? And could you outline for us briefly the way that you think the rule of law has tended to be thought about in the Catholic moral tradition, including perhaps some of its major dividing lines internally and externally? What differentiates it from other traditions outside the Catholic tradition, but also some of the dividing lines within the Catholic tradition of thinking about the rule of law?
Wow, that's a great comprehensive exam question. And I am going to write that down and give it to one of my students. I guess I want to start in the middle. So there was this very famous legal philosopher named Lon Fuller, who taught at Yale Law School, who just kind of came up with the classic mid to late 20th century definition of the rule of law for the secular world. And it's called Eight Kind of Excellences Toward Which a System of Rules May Strive. So his view is that the rule of law's requirements are that law be general, that it be publicly promulgated, that it be non-retroactive, that it be sufficiently clear, that it be non-contradictory, that it be possible to comply with, that it be relatively constant through time, and that there be congruence, he says, between official action and declared rules. Others people call these the formal requirements of law, but Fuller himself called them the internal morality of law, which I thought was really interesting. And that made me think of St. Thomas Aquinas, because Fuller's list didn't seem very strange to me. It seemed to have common sense in it, right? But it also seemed as if it were something that had echoes of a Thomistic understanding of law, which more or less is tacitly running through the whole Catholic social tradition's view of what law is. So Aquinas defined law as an ordinance of reason for the common good made by him who has care of the community and promulgated. So that's what a law is. And then he quotes Isidore of Seville and saying, well, what is good law? Law shall be virtuous, just, possible to nature, according to the custom of the country, suitable to place and time, necessary, useful, clearly expressed, lest by its obscurity it lead to misunderstanding, framed for no private benefit, but for the common good. Thinking those are more or less Fuller's criteria of law. They're flipped around a little, they're phrased a little bit differently, but they're more or less the same thing. What does that tell us? What can create a bridge, therefore, between the secular view of the rule of law and the Catholic view of the rule of law? And the answer really that came to my mind was pretty simple. The rule of law's requirements are what the law needs to actually function well as law. You know, you've got a sense of what law is, and then the rule of law is what it needs to function as it's supposed to function. So if law is a rule and measure of human acts, it has to guide people's behavior. It has to be clear. It has to be non-contradictory. It has to be publicly promulgated. It has to be possible to comply with. People are planners, right? You know, human beings plan for the future. We have nested sets of intentions. Mm-hmm. So it has to be relatively constant through time, and it can't be retroactive. You can't plan for the past unless you're in some sort of Star Trek movie. And it has to lead people to the common good. And this is where the substance clearly comes in, but it's in all of them because it's about human acts. So the law has to be general, and there has to be some congruence between the actions of the officials and what they proclaim through the law. Legal justice is common justice. It's law that's meant to organize us all in a community. So what I saw through looking at Fuller and looking at Aquinas and while it's not always cited, the Thomistic definition of law as an ordinance of reason, for the common good just permeates Catholic social teaching. I realized we had the potential for a tremendous overlap. And that's why I saw this as working out. Now, on the procedure and substance side, I want to be ironic. Yes, there are a lot of, the lawyers tended to focus more on procedure, the secular lawyers at the conference, and the requirement of notice, fair hearing, things of that sort. And Catholic social thought, tends more to focus on, overall, I think, the rights that are protected by the rule of law, the fact that you have to get certain, rights of, economic rights, family rights, dignitarian protections in the system, but it doesn't talk as much about procedure. And what I think is necessary, and we're starting to see the turn in the conversation, is that in order to protect those substantive rights, we need to pay attention to the procedure because that's how those rights are protected.
Mm. Yeah. Okay, so I want to take that and move us into a much more fine-grained distinction. And this question is here because this is partly a bugbear of mine. So this is a
Yeah.
slightly self-indulgent question played out on you, which is I often have to make a distinction when I'm talking to people about the rule of law in the context of Catholic social teaching between democracy and how Catholic social teaching understands democracy and how it understands the rule of law. This is not helped by the fact that the compendium, blessed though it be, of the social doctrine of the church manages to sort of put the rule of law under a heading that's about democracy, which makes it look like it's a subcategory of democracy, which it isn't. So talk to us about why democracy and the rule of law might be related, but they're actually different things to be thought about differently and why it's important to treat them as such. Indulge me for a moment.
No, I think that that's an extremely important question. And I guess the nutshell answer is the rule of law does not presuppose democracy, but any functioning democracy presupposes a robust understanding of the rule of law.
Exactly.
And so the way I think of it is like a spectrum, so we can start on one end of the spectrum and then get to the other end. And the left end of the spectrum or the right end of the spectrum, I'm just doing a ruler chart. It depends on which way you're reading it. Let's start with tyrants. Tyrants, not Democrats, not democratic rule, but a tyrant. If you think about a tyrant, well, a tyrant is bad, but an unpredictable tyrant is a lot worse, right? Um, Predictability on the part of rulers, at least no matter how bad they are, you can plan around them. You can make the most of whatever scope of activity that you have left. You know what you need to do to get your food, to get your shelter, and preserve your life and go about your day. But think of a tyrant, say, who wakes up and decides, maybe they've been watching a little bit too much YouTube and, they're thinking about the lights in the streets and the colors. And suppose the tyrant wakes up and decides that green lights really should mean stop rather than go. After all, green energy is peaceful, it's calm, so it should mean stop. And red lights should mean go because it's movement and energy. And if they suddenly decide that, the next day, switch all the lights, we're all going to end up in tremendous car crashes, right? Because our lights are going to be all messed up. Nobody's going to know what to do. Or if a tyrant got up and suddenly decided, we're going to drive on the different side of the road, that's going to create chaos, not just for people, but for car manufacturers. We still have to get around in a tyranny. People still have to make, trucks and buses and cars, and they make the steering wheel go to the place that makes the most sense given the rules of the road. All of that has to change. So some sort of predictability, some sort of publicity is necessary for an effective tyranny, or at least a better than, minimally awful tyranny. Then move from that point to sort of basic procedural protections. You don't need to have a full-blown democracy to say, the basic protections of the criminal law, for example, due process protections in the US, which protect against arbitrary decisions and ensure fairness and generality of the law, say indictment by a grand jury, trial by a jury of your peers, a timely verdict. You don't need to be a democracy to say those things are good. I mean, we started protecting that way back with the Magna Carta, right? The kind of general basic understanding that there was a certain set of procedural protections, particularly when depriving people of life, liberty, or property, that had to be followed. That doesn't get you to a democracy. But one step along, you're moving toward a democracy, and you say, well, all right, we are going to be a democracy. What do you need to have for there? You need not only basic procedural protections and basic requirements of generality, but fair and transparent laws of participation. Who gets to vote? How do they vote? How do we count the votes? How do we make sure the voting system is fair? How do we get the representatives in a representative democracy? How do we make sure that no one branch of a representative democracy takes over? So you have the checks and balances that you need in order to make sure that the executive isn't deciding all the, interpretation of the laws they make in their own favor. So you end up with a whole elaborate set of procedures. The US Constitution is one, the unwritten Constitution of England's another, where you work out what this requires and you publicize it. So I think that you cannot have the democracy without the rule of law. And, you need to have a certain view of law, I think, that fits very well with Catholic social teaching. Catholic social teaching doesn't have what's called a bad man theory of law, which is, a view of law that says, well, if we were all not sinful, we wouldn't need law. Law is just to keep the bad people in our society in check. Catholic social thought and Catholic views of law in general say, yes, we would need law because we'd need to solve what John Finnis called our coordination problems. Which side of the road do we drive on? If you're going up to kiss the throne of God, which way do you process, and how do you go back to your seat in the heavenly choir? You need to figure those things out. So law has a positive function, but Catholic thought is also realistic, and I think that fits our democratic view. There is nobody that's an angel. We're all, to some degree, sinful. So part of what we need to do is design a democratic framework that will protect us not only, from bureaucratic glitches, but from the worse angels of our nature, not so that the better ones can flourish. So I think if we think of the rule of law on a spectrum rather than as one thing, we get a better sense of how it fits with the question of democracy.
Thank you. That's really, really helpful. And you've already started to move us into the territory of the next question that I wanted to ask, which is about the social encyclical tradition specifically, because I don't want to reduce the whole of the Catholic moral tradition just to the encyclicals, but I think we need to deal with those as a specific kind of narrative frame for thinking about some of these questions. And one of the things that strikes me is that it's there already in Rerum Novarum. So Rerum Novarum has an account. It talks about the rule of law in a certain kind of framework. And actually, some of the pre-Vatican II encyclicals, two of them, obviously, talk much more about the rule of law in terms of actual mentions than the post-conciliar ones, even though the more developed articulation of a Catholic approach to human rights and rights in general, in pacem in terris, etc., obviously offers that more kind of developed framework. But in fact, the rule of law as a theme is there in the earlier encyclicals, probably more so than the latter ones, although with the interesting exception that Fratelli Tutti makes more mention of the rule of law than any of the sort of recent encyclicals. And Pope Benedict used used these particular speeches to legislatures that he made in Germany and actually here in the UK to sort of set out some of his own thinking about the rule of law. So what to you stands out as particularly helpful from the encyclical tradition specifically, and what raises questions for you from the encyclical tradition in terms of the rule of law?
That's fantastic. And again, your own work on the details of the encyclical tradition has been so helpful, for me in grasping some of this. I've just got a couple of high points that I see from a couple of the encyclicals that might be helpful. So if you go back to Rerum Novarum, you're entirely right. The state as presented in that as maintaining and developing, the rule of law, and it's also rooted in the anthropology because he talks about Pope Leo the 13th, that is, talks about human beings as guiding. They're rulers and masters of their own acts, and they're acting under the eternal law, which filters down through the natural law, which should be respected by the state, which proposes the positive law. So you've got a presupposition of a system of law that includes not only divine human law, positive law, but is related back to natural law and before that even to eternal law.
Yeah.
And I think that that's important. The second thing is, the notion of order is very prominent in Leo's work. Law is part of what's guaranteeing people the tranquillitas ordinis, the tranquility of order that allows people to rule their life. And that is another way of thinking about the rule of law. It's predictable, it's fair, it's steady, it's well regulated. But there is, and I think this is a really fascinating point in Leo's encyclical in Rerum Novarum. I teach contract laws as my day-to-day bread and butter course in the law school, and one of the arguments that was made in the early 20th century, late 19th century, was that there was a sanctity of contract. So if the shipping magnate and the lowest worker got together and negotiated a price for the services of that worker, that was a sacrosanct agreement blessed by autonomy, and the state could not interfere with it. It could only enforce it. What Leo says is no, that contract matters, but you have to recognize how to interpret it is going to have to depend on the purposes of the contract, which is to give the worker enough money to support the family. So we can't interpret and enforce unjust, today we would use the word unconscionable contracts, in which the owner of the factory or the shipping magnate took advantage of their bargaining power to exact less than a just wage out of the workers. So there's a recognition from the very beginning that the rule of law, the enforcement of contracts, nothing, just the enforcement of contracts, can't be separated from the substantive questions of justice and the purpose of the contract. I think that is actually fascinating. In looking at Rerum Novarum. When you get to Quadragesimo Anno, you also see some focus on the rule of law, but there's also a shift, I think, that is really important. You see a shift toward not just law understood in the way Fuller did and the way Aquinas did, actually as characteristics of individual laws. He's looking at systemic order, systemic control over things like economic life. So law can't be looked at just by taking one particular provision out of a network of laws that orders together. So we've got a movement toward, not just law, but laws. What does that whole network do? How are we regulating whole spheres of life, like the economy? So one line here from him, I think, is paragraph 88. destroying through forgetfulness or ignorance or social and moral character, the social and moral character of economic life. It held that economic life must be considered and treated altogether free from and independent of public authority, because in the market, i.e., the free struggle of competitors, it would have been a principle of self-direction which governs it more perfectly than would the intervention of any created intellect. So he's basically saying that's not true. We can't just look at the economic sphere as something that's just a question of enforcing the deals made by private participants in it. We have to set it up and structure it as a system that works for everybody. So you see in Quadragesimo Anno a real move toward law as system.
Mm.
Then when you get to Pacem in Terris, what I see, and you pointed this out to me as well, and I think here is where you see the connection between human rights on the one hand and the rule of law on the other. And when I reread Pacem in Terris this morning in preparation for this, what I was struck by, because you don't think of Pacem in Terris this way, is its emphasis on order. Right? It's order between men, order in the cosmic realm, order in the state. So where he's building the connection, John the 23rd, between the rule of law and rights is through ontology, through the order of being. What you have to get right first is the order between men, and we would say men and women. And he says that any well-regulated and productive association of men in society demands the acceptance of one fundamental person, that each man is truly a person. He is a nature that is endowed with intelligence and free will. As such, he has rights and duties, which together flow as a direct consequence from his nature. These rights and duties are universal and inviolable, and therefore altogether inalienable. So that to me is the key passage. That passage has been picked up, by subsequent Catholic social teaching magisterial documents, but it has focused more, I think, not exclusively, but emphasis-wise, on the rights rather than the order that creates the rights. And part of what we need to do now, I think, is go back and pick up the notion of order and think of the juridical order and what's necessary substantively and procedurally to protect those rights. So that brings us, I don't want to keep talking, but that brings us up to the cusp of the Second Vatican Council, I think. But you can ask me another question or to pursue or what you'd like.
Sure. So, you may or may not want to comment on this specifically, but I was really struck looking at Benedict's reflections on the rule of law, that you could miss them because they're not primarily there in Benedict's social encyclicals. They're much more there in these individual addresses, particularly ones that he gave in legislative contexts. Is there anything that you would want to say about, and there may not be, but if there's anything you want to say that would pull out anything that you think is either distinctive, do you think Benedict pulled back in terms of some of the moral order stuff that was there in Pacem in Terris, framing individual rights? Does that become a crucial part of what he's partly trying to keep hold of and then bring back to the fore again? What have you got anything on the kind of Benedict era stuff that you would want to say?
Yeah, a couple of points. I think his address at the Bundestag in September 22nd, 2011, right after, we're still very much close to the over response to terrorism, the situation where the world is kind of falling apart. So, and the sense that we can do anything to achieve our goals, I think, is still a big dominant point there in the secular world. And what I see him as really trying to look at the rootedness of good law in natural law and in the eternal law. The fact, and he's not trying to propose a detailed theory of natural law here. He's trying to say, hey, look, the awe comes from the is. It's in the sharp Humean separation between is and ought, doesn't work. Our oughts come from our ises. This baby's hungry. We should feed the baby. And we've got an is about human beings are, as Alistair McIntyre said, and an is, kind of a vision of who we should be. And our oughts are connecting who we are with who we want to be as a community. And I think he's very much concerned to resist the idea that law is only a matter of positivistic, proclamation, that any law, if it's promulgated, functions completely as law, because he's got the horrors of Nazi Germany in his mind. He's got, some of the atrocities that were going on in the world at the time. And what I found very interesting was in that talk was, he came back to Kelsen, was one of the great legal positivists, and who came up with a legal theory that was based in the dualism between is and ought. And he says, hey, Kelsen at the age of 84 in 1965. What I loved about Benedict here was he's got a little aside in the remark. He says, I find it comforting that rational thought is evidently still possible at the age of 84, because Kelsen was 84 when he came up with this remark, said, hey, you know what? I was wrong about the dualism between is and ought. We can't separate them that much. Whoops, my bad. He didn't say that, but so the idea that this great thinker would rethink a foundational point and say, no, we need to connect them. So Benedict is, I think, about bringing in some way, the notion that there is a natural law, that it is rooted in the eternal law, and that it has to, in some sense, generate the positive law. Now, this doesn't mean everybody gets to say, well, I don't think this is in accordance with the natural law, and so therefore I'm not going to obey it. Even Aquinas was not that crude, but it is talking about the relationship of law to human nature and human flourishing. And we can argue about the details. So that's what I saw there. And on the address at Westminster, which was also wonderful, and I think that he's exactly right about the common law tradition. He wrote that, quote, your common law tradition serves as the basis of legal systems in many parts of the world, and your particular vision of the respective rights and duties of the state and of the individual and of the separation of powers remains an inspiration to many across the globe. What he could have added, he does go on and say, the common law and Catholic social thought have a lot in common. In some ways, we use a different language. Well, if you go back to the history of the common law tradition, it came through Blackstone, and before Blackstone, Hooker, and the judicious Mr. Hooker borrowed a tremendous amount from Aquinas without appropriate citation, one might say, because of the religious polemics. So there is a tremendous amount that Catholic thought can see in the common law about how to organize a society and how to think about human action. I mean, there's differences and divergence, but there's a big platform of commonalities on which to build and converse. So I thought that was very good too.
Yeah. And I'm going to just make a comment. I'm going to turn the next question just into a quick comment so we get to the last question before we finish, and to have enough time for questions from other people. So one of the things that really strikes me about Francis is that I think Francis, he's accepting all of that framework that he's inheriting, but he turns us towards civil society, and he turns us back to that spheres of life context that you were talking about earlier. And he makes the rather controversial point, in a sense, although I also think it's true, that the rule of law basically depends on a healthy civil society and a decent political culture for its vitality. And if the rule of law is under strain, then civil society has probably failed in some way first, and that we have to be able to sort of confront the historicity of that. So he places us back in history, time, context, and those spheres of life to think about the rule of law as a living thing. So he's bringing that different angle of gaze, if you like, I think, to Benedict. Anyway, if you can comment on that if you want to. But my final main question to you, which is a slightly playful one, is that we know at the moment that a new social encyclical is imminent. if Pope Leo called you up and says, well, there's probably only a few weeks before this text might be made public, and said that he wanted to write something diagnostic on the rule of law in this moment now, a kind of signs of the times piece on the rule of law and where we are that drew from the Catholic tradition, what would you want Leo to write? What would you advise him to be writing in this moment in terms of a kind of diagnostics, and in terms of drawing on the bits of the Catholic tradition that you think can most speak to us in this moment?
Okay, well, that's a really good question. I can think of a couple of things. One is I think people think of law as merely an exercise of domination or power. My side wins. I get in, I put in place the rules I think are right. That's my prize for having won, at least in the United States. I recognize politics elsewhere might be different. I think that we should emphasize that the law has got to be meant to further the flourishing of all people, in the context of the common good. It's not meant only to be an exercise of dominion. It's judged by its positive function. Then secondly, and I think this is important and goes a lot with your own work, Anna, I think we need to think of the rule of law as an aspect of solidarity, in the sense that, part of what solidarity is, willing the good of all. So solidarity in the legal form is a system of institutions and protections that knit us all together and give us all the ability to rely on one another. So I think the Catholic social teaching defense for the rule of law will come through a deeper understanding of what society requires of public institutions.
Okay.
And here's the challenge, I think, and this is a challenge for law as all. The challenge that we face is, how do you think about law being fair on the one hand, and about law as providing or instantiation of an option for the poor and the vulnerable without violating fairness? Pope Francis was very concerned about, how the law affected the poor and the vulnerable. And so there are ways of doing that. We go back to Leo and the contract between the shipping magnate and the dock worker. You could just take a pure fairness view and say it doesn't matter, whatever they agree on, they agree on. Well, no, we can't do that.
Mm.
But on the other hand, we don't say, well, the law of murder is different for a poor person than for a rich person. So there are certain things that are the same. There are certain things that are shifted. How do we take into account people's position and vulnerability without violating fundamental fairness? And I suppose the fourth thing I think he needs to point toward is overcoming dichotomies, the dichotomy between the is and the ought. How do we incorporate a concern for natural law and natural rights in a way that doesn't sound spooky or misleading to a largely secular context? And I think we need to overcome the dichotomy between procedure and substance, because both of them are necessary for flourishing. Those would be my 4 points if he should call me up one day.
I hope he does. I hope he does, and soon. So now is your opportunity to join in this conversation. You can do so by typing your question into the chat. So if you want to now get busy, we've got 20 minutes, which is what we hope for questions. So you might want to push something that's on the kind of more theoretical side of what we've talked about. You might want to think about the rule of law right now and how you see it as something that might be under significant strain. You might think that kind of that analysis of crisis is overplayed. Bring us your questions and we will do the best that we can in 20 minutes. Try and keep them reasonably concise to make sure that we can get through questions from a number of different people. And as I said, if you put it in the chat, then I'll be able to pick up your question. And just to give people chance to think about their question for a moment and put it into the chat, I'm going to ask Cathy a completely different question for her to riff on just for a moment, given we've had an eventful week in terms of the politics of the Catholic Church and your own home US context. Give us a quick read of that, Cathy, from your perspective, but do not allow this to completely distract you from writing questions in the chat. Okay. Otherwise,
It's
you'd be
just,
left just with my questions. Carry on, Cathy.
I would just say it's surreal, right? I mean, the idea of the president of the United States, bursting forth with a whole bunch of blue scatology on Easter, and then, attacking the Pope and the vice president telling the Pope that he needs to, brush up on his theology before pontificating although that's his role, on these sorts of things. But what I really think is sort of interesting is, there's a debate going on here about it's a little bit of a romantic debate. I don't think it's made it to the United Kingdom yet, but there's a group of Catholics that want to return to integralism, the merging of church and state, and that's the Catholic version. There's differences of Christian nationalism that's floating around here these days, and I think what they think they're going to get is, I don't know if you all saw the movie The Young Pope, which had Jude Law and looking fabulous in a triple crown, kind of restoring kind of order to the whole world in some way, kind of ruthless but still compassionate. And that's not what integralism looks like. Integralism looks like Donald Trump just as Jesus ministering to a sick country in a sort of bad AI image. So what do you learn from that? I think you learn that, integrating church and state is not good for the church. It can be good for the state. So we better be careful for what we wish for, because we may not want it when it comes.
Okay, there we go. So that was good distraction and a very good answer while we were waiting for some questions. I've got one question which I'm going to read out. I truly hope somebody else is going to ask another question. So do be brave. Ask whatever you want. You've got the opportunity of
Sure.
having Cathy, who's totally fabulous here, to answer your question. So you can ask anything you want. Raymond Friel, who works for one of our Caritas, he heads one of our Caritas agencies in the UK, Cathy, to give you some context, and has got a background as a head teacher in Catholic schools as well,
Nice.
and writes on Catholic social teaching. How do we arrive at the conclusion that a state's law is an immoral law? And if so, should it be resisted? So, I mean, classic question of the tradition.
That is a classic question, and it's not as easy as it looks, right? I mean, because you say, I'll just go back to St. Augustine. You can't always say, well, it's permitting bad behavior, and so therefore it's got to be an immoral law. And we have to enforce all good things and prohibit all bad things. That doesn't make it an unjust law. If a law does not prohibit all bad things. Even St. Augustine said, hey, these houses of prostitution, they're not great. I really don't want you to go, but we can't shut them down, because that's going to cause more disorder in the community than it will provide benefit. Things will go underground. So what you have to kind of look at in deciding whether a law is unjust, is it requiring an act that's very bad? So requiring you, say, to shoot your third born child or something like that, that's clearly unjust and has to be resisted. But it gets much more complicated when the law is permitting people to do things that you don't think that they should be doing, or when it's funding things that you don't think should be funded.
Okay, that's really helpful. So Richard Finn, you may know Richard already, but Richard is a Dominican based in Oxford, who is a fantastic historian as well as a activist and scholar of Catholic social teaching, amongst many other things, and hats he wears.
Right.
Richard asks you, how can the church best defend and promote the different elements of international law, in your view?
Could you just ask him what he means by the different elements?
Richard, unmute yourself because you're very capable of explaining this yourself.
Okay, thank you. Thank you for a superb talk and answer to questions. It's really good to listen and to learn from. I'm thinking about, for a start, the different sorts of courts that are at play in international law, the different areas of international law, some to which the United States signs up to, some to which the United States doesn't sign up to, and so on. And I'm aware of the fact that in recent encyclicals, recent popes have wanted to strengthen international law, and the enforcement of international law through international bodies, but there hasn't yet been much detail or substance to how that might be done.
That's a really good question. And the person who, just for future conversation, she was also at the conference in Boston, who's a real expert on this, is my colleague, Mary Ellen O'Connell, who teaches at Notre Dame. But I would say right now, we're not in a position to promote a world order. We've backslid a lot. That partly what we need to do as a Catholic Church is shore up an understanding of us as being one people, as everyone mattering equally, as being in a communion of people, as opposed to the various forms of nationalism that are gripping and tearing apart the world. So what you have in the United States is a strong kind of nationalist. Sometimes it's Christian nationalist, sometimes it's nationalist. Our rules are just for us. We're not going to listen to what you all are saying. So there's been, years and years of the Supreme Court rejecting certain aspects of international law. Even if we sign the treaty, we feel like we can break the treaty because it's not binding on us, if they can't punish us. So I think we're at a point where the church can't say, well, we've got to give more teeth to the law. What the church has to do is say, here's why this whole system still makes sense. Here's why talking about a global order, even if it doesn't have full teeth, still has some weight. I think we're back at that point. I don't think people see any point in a global order in many places, like in the United States.
Richard, do you want to come back on that, or are you?
Yeah, well, just very briefly, I mean, my worry would be if you take something like the climate emergency, have we got time to wait for that reversal of backsliding?
Well, I mean, I no and yes. I mean, I think you have to. We're not going to get any response to the climate emergency from this administration in the U.S. They're undoing everything as fast as it can be done. So you have to put in place something that's going to be able to be rolled out when we're not run by this group of people. But trying to tell this administration and this group of people that what you really need to be listening to is The Hague and the other international courts, I don't think is going to get very far. I don't think most American Catholics, and I don't know how it is in England, really see the point of a universal community. What's been most difficult for me to watch in this, I don't know what you'd call it, between the Pope and the President, has been the degree to which, there's a certain strand of American Catholics that think the Pope is wrong in kind of focusing on all of humanity and the interests of everyone, rather than just recognizing every nation has to pursue its own glory and power.
Mm.
I think we've not gotten as far, even in our own catechesis, as we need to.
Yeah. And thank you for that exchange. I'm going to now turn to David Byrne, who also works for our domestic facing Caritas agency and is a young theologian in his own right as well. So he's working academically and at the practice interface. Nice. So he says, thank you very much to you, Cathy, for a wonderful seminar. His question is, how can the preferential option for the poor be operationalized in law to protect vulnerable groups while still preserving the predictability and impartiality that's required by the rule of law?
That's not just a $64,000 question. That's a $64 million question. I mean, that is the question, right? How do you meld mercy and justice? How do you take into account particularity and generality? That is, if anybody is going to help solve that, I think it's the Catholic anthropology of individuals mattering, but also the group mattering. I think you can start by ensuring that, there's basic representation, of of people who with limited resources, by public defenders, not only in cases of criminal law, but also in cases of civil law, if they're threatened to be evicted, in hospital settings, if they're dealing with Medicare, Medicaid here, or the health services there. I think that lawyers can do a lot more to provide a voice for those people. I mean, then on the substantive level, I think we need to, adopt a view of law that's, I mean, you don't have to look at it all as a power relation, but you need to recognize that if we're talking about autonomous agreement in a contract, that that people have different power relations and different educations, and that needs to be taken into account when we interpret context and when we talk about the doctrine of unconscionability. I think we need to recognize, and have a Supreme Court and other courts that don't look like they're ready to knock down legislation that was protective of people in more vulnerable circumstances, including, public school funding, and including, education and including food, because all of that empowers people to be able to voice their own arguments. I think you need to allow. Pope Leo the 13th was very much in favor of unions, and they've been kind of busted in lots of places in the United States. What kind of organizations will allow people to get together and work together and maximize their voices? All of that is I think what we need to be doing, rather than allowing the isolation of people. And any person, no matter how intelligent or articulate they are, is vulnerable if they're isolated.
Thank you. And then we've got a nice challenging question that turns the angle a little bit to be more critical than perhaps we've been so far of a specifically Catholic only account, as it were, of substance of law. So Nikki, who's based with the Jesuits in London and is a theologian, again working at a church and society practice interface. Nikki is asking, is a specifically Catholic substantive account of law necessarily limited in its ability to consistently oppose the far-right politics that abuse the rule of law? And she says she's thinking particularly of the history of Catholic anti-feminism. So is there kind of such a problem in terms of the capacity of the Catholic substantive tradition to deal well with the reality of women, as it were, before the law and in society, that this problem has actively fed into far-right politics to the point that, she says, the US CCB actively endorsed Trump's transphobia executive orders, even as they condemned his border policy?
Well, I mean, I think that the Catholic Church is a messy and confused and conflictual community, like any, big family, right? So you've got different views of what counts as Catholic teaching and what the priorities are in Catholic teaching. And we saw that, I think, in the United States, because I don't know if they did to the same degree in the UK, but here, for example, our bishops took John Paul II's encyclical Evangelium Vitae and the notion of the culture of life versus the culture of death and politically weaponized it. If you read Evangelium Vitae carefully, it's very clear that, Pope John Paul II is no fan of abortion or euthanasia. That you can't argue against, that point. But his main point in the encyclical is pointing out how a culture of life doesn't just prohibit wrongful acts, it also provides positive care and support for vulnerable people in a whole range of situations. A culture of death, might leave abortion and euthanasia and unregulated, but it isn't going to provide any help for people who are dealing with crisis pregnancies or with complicated and painful end-of-life situations. So what John Paul wanted to do was bring together both the legal prohibitions, but also the big social support for vulnerable people. In the United States, that got weaponized, and part of the vision got cut off, particularly by the Republican Party, who said the Republican Party was the party of life and the Democratic Party was the party of death. Why was the Republican Party a party of life? Because it believed in outlawing these practices. but it didn't support providing, great social services supports. It didn't provide for, support for immigration. It just provided for a focus on mainly abortion, contraception, and, as you say later, trans issues. So we've got a church that's highly divided. In the United States and maybe around the world. I think the best we can do is maybe not draw on the, citing encyclicals per se as if they're authorities, and then you got another authority used against another authority in the external discussion, but drawing on the substance of the points: dignity, vulnerability, community, common good, and then fleshing out what that is. Rather than just citing authorities. And I think that can be done. Now, on the women's issue, I've got complicated views on that, because as it turns out, in the United States, at least, the people who were most responsible for the subjugation of women weren't Catholics. It was actually evangelical Protestants who, had a more biblically based view of what women, were and could do. And they're the ones who are really leading the move to take the vote away from women. Can you believe that? Here, it isn't the Catholics. In the United States, you have this tremendous model of women who were doing tremendous things as sisters, founding organizations, promoting the well-being of the poor, dealing in a powerful way with bishops. That was all a possibility for women, as opposed to what was the case in America, for the longest time, which is you'd lose your legal personality as a woman if you got married. It was like a social death. So I think there's a tremendous amount to be drawn on, even if we acknowledge there are things that, are not what we would want in the history of the Catholic treatment of women. And any retrieval of a tradition is always a selective retrieval. You're not retrieving the whole thing.
Okay, and you brilliantly finished giving us 30 seconds to say, Cathy, thank you so much for giving your time, your erudition, your energy and sharpness of mind to us this afternoon,
pleasure.
your time, this evening. We hope we'll be able to persuade you back for something in the future, but for now, I think I speak for all of us in saying you've given us a really stimulating hour.